the Financial Intelligence Center is racing against time in getting out of the grey list next year. The Financial Action Task Force has given the Financial Intelligence Center until May this year to address the non-compliance of reporting requirements by legal practitioners' offices and the estate agents, which are considered as high-risk sectors for money laundering and terrorism financing. Joining us now for this discussion is Christopher Malan. He is from the FIC's head office in charge of compliance and prevention. Mr. Malan, good evening to you, and thank you for your time. Let's begin with the question that is quite straightforward. Is the attempt to remove South Africa from the FATF grey list in jeopardy?
Thank you for the opportunity. We need to view this within the broader framework that there are 22 action items, and all 22 needs to be largely addressed or addressed come January next year. Our concern is that the FIC is responsible for key sectors such as the legal practitioners and estate agents, and we have a deadline of May this year, and we have the responsibility to ensure that we have in place a risk assessment tool to identify high-risk entities in our sectors, and with a particular emphasis on the estate agents and legal practitioners, as you said, because they are higher risk. So we need to ensure that we receive most, if not all, of the risk and compliance returns, which is input data to be filed by every attorney, every estate agent's office with us to enable our risk engine to calculate and determine which of those are high risk. And should we be able to get that in sufficient numbers, our tool will have credibility. It will be viewed as we would have discharged that obligation largely, and we would be able to discern a group of high-risk entities to inspect. At this point in time, we do not have the numbers, and that is why there is a concern that we may not meet the deadline if these two sectors in particular, and other sectors as well, such as trust property service providers, do not increase the numbers of submissions to us. So yes, we won't say we're not going to meet the target, but we'll require business to be part of the solution.
Yeah. Why is it, Mr. Malan, that the legal practitioners, or should we put it plainly, why are lawyers and estate agents identified as high-risk areas, particularly when it comes to money laundering and terrorism financing?
That classification is a classification which you tend to find around the world in the FATF jurisdictions. It is by the very nature of the work that they do. First and foremost, the legal practitioners are involved in structuring and setting up companies and trusts, and are seen as gatekeepers and facilitators of transactions through complex structures such as companies and trusts, which then obviously, by setting up those mechanisms, removes the natural persons behind the misdeeds and their proceeds, and they sort of are covered by this complex structure. So that functionality of beneficial ownership, as it's known, is at play. The property practitioner sector or estate agents is renowned worldwide that whenever there is illicit or proceeds of crime, the first port of call or the obvious port of call is to buy, luxurious houses or any house where they convert the proceeds of their crime into a tangible real estate, and it's because of that complexity, including when the purchaser is further removed from the matter by a trust or a corporate structure, natural person sitting behind that, buying the property through trusts and corporate structures, but the entire scheme is financed by laundered funds.
Very interesting indeed. A very well thought through response there. Let's then talk about whether it is FATF itself that has flagged lawyers and estate agents as high risk, or is it yourselves, the FIC?
We have both. In the sense that the FATF have flagged that area, those two sectors as areas of concern in our mutual evaluation report, which, as you may know, was published in October 2021. They identified those two sectors as particularly vulnerable to money laundering. The sector risk assessments which we did, and from our engagements with industry, we have come to the same conclusion. We've issued sector risk assessments that attribute to these two sectors the risk categorization of being high. Now, obviously, we are dealing with a situation of high here, in the sense that for these two sectors that are deemed high, we are required under the action item that is applicable to the FIC to, within these high sectors, high-risk sectors, to identify further the high-risk entities operating in this high-risk sector.
Yeah.
And we are largely dependent upon them recording their risk and compliance situation in our risk return, sending it to us electronically to enable us to evaluate, to determine which of those are high, which of those are not. And at this point in time, due to their non-action, we have deemed every one of them to be high, which is not ideal. We would like them to take ownership of their reputation and seek to assist us by filing all outstanding risk returns immediately to enable us to discharge this obligation timelessly. And I said the deadline is May, so we are running out of time.
Risk and compliance reports, by their very nature, they require companies to provide detailed and sometimes sensitive information. Could that be the reason for reluctance to report, you think?
We don't regard it as such, and we'll explain why. Each and every accountable institution, and in particular these two sectors, and it is applicable to all other sectors as well, are required to understand their business risk as it pertains to money laundering and terror financing. And they have to undergo an entire process of a business risk assessment enterprise-wide, where they evaluate their clients, their products, their distribution channels, their geographic location, and the like, and to move that information, once they have determined their risk profile using those combination of areas, into what we call the risk and compliance return. So they have the information, or they ought to have the information. The FIC Act clearly says that the description of your clients is not confidential, because we are not asking them to disclose, is Mr. ABC your client? We are saying, we ask them the question, tell us how many of your clients are foreign, how many of your clients are local, how are you interacting with your clients, what are your products, what are your services, and the like. So it's not granular personal detail, it's aggregated data, and there should be no rational reason for them not to be compliant.
As things stand, based on a report I read, there's about 16,000 legal practitioners' offices in South Africa and some close to 9,000 estate agents that are operating in South Africa. What kind of penalties do these entities face should they not meet your compliance standards?
Well, let us be very transparent about this. The issue is not the penalties. We are not seeking to chase penalties for the sake of penalties. We are seeking compliance. We are seeking adherence in a key risk assessment process that, should they robustly and honestly answer the return and send us the information, will enable us to make informed decisions, having looked at our risk engine, determine high-risk entities, so that we have a pool of high-risk entities from which we will design our supervisory plan and from there inspect. That is the FATF expectation, and that is the expectation I've explained, which sits in our action plan. So our first issue is to ensure we issue them with a notice of sanction, which directs them once more. But it's not the first time we have directed them to do this. We are directing them once more in a sanction notice. You've got 10 days to file this. In addition, as a competent supervisor, we cannot ignore this egregious length of non-adherence, and it is incumbent upon us to issue penalties. And we are required to do so because the FATF methodology says that where one goes through a process like this and where you have ratcheted up your engagement with industry and reach a point where you sit on a cliff in a sense and you're dealing with an industry or an institution that just won't cooperate, your only other supervisory tool is to issue a sanction, which you hope will change behavior. But we are appealing to our business communities here, in particular our legal practitioners and estate agents, to take a country perspective, to view the inaction as definitely going to cause themselves reputational reputational harm, potentially domestically and internationally, should they not come on board to assist us, do the right thing, file the return with information they do have. And yes, unfortunately, we would have to issue a sanction as part of the notice of sanction, compelling them once more to file the return within 10 days.
Final question, and very briefly, if you can. Should you miss the May deadline, your comments earlier this week were, and I quote, "We will fall off a cliff." What do you mean by that?
Well, it's a credibility cliff in the sense that the entire financial system operates on trust and credibility. And as a supervisor, there is an expectation, if we just look at the methodology, that our institutions, our businesses are credible, and in their interaction with us, they reveal information when it's required, they do the right thing, they enable the regime to work together to combat money laundering and terror financing. There are two streams of thought here at play. The first is that if the businesses themselves are not making the right steps and the right actions and putting in place the countermeasures, which first and foremost protects them, there's a credibility issue. Secondly, the FATF methodology is crafted such that if the supervisor allows this state of affairs to occur over a period of time and is seen to be supine, not taking action, not being competent, not galvanizing industry to work with the supervisor, there's a credibility issue. So on those 2 points, we are sitting at that cliff, which if circumstances don't improve, in my terminology, I think we're facing a situation where we'll fall off the credibility cliff, both as business and as supervisor, and the country itself, because we'll be viewed as not being able to deal with this issue timelessly. There's no rational reason not to comply timelessly, and we need to be doing this in the national interest. So we will definitely lose credibility, and once credibility is lost, it will be very difficult in further reports that we file to come and try, and we would have fallen into a void in a sense, and it's difficult to recreate that level of credibility which currently we do hold with the FATF, we must seek to retain it at all costs.
Christopher Malan, thank you very much for your time.